courtroom, this decision has to be made without passion. It's a decision that has to be made based on the evidence, based on the law, based on what's just, given all the facts and circumstances. The jury in this case found the defendant, Robert Olsen, guilty of an aggravated assault. And that aggravated assault led to the death of Anthony Hill. Now, whether they found him guilty of felony murder or not, the facts are still such that the shooting that this defendant committed led to a death. I say that because there's really no worse aggravated assault you can think of than an aggravated assault that leads to someone's death. There are different types of aggravated assaults. There's pointing a weapon at somebody, threatening somebody with a weapon, brandishing it, harming them, whether with a knife or a gun, causing an injury. But there is no worse aggravated assault that could be envisioned than one that ends in the death of the victim. And I say that, Your Honor, because the legislature has deemed the sentencing range for aggravated assault from 1 to 20. Reasonable people would say that 1 being the least egregious of the aggravated assaults, and 20 being the most egregious of the aggravated assaults. Otherwise, they wouldn't have made 20 the cap. It would have been 10 or 12 or 15 or whatever number was deemed appropriate. Based on that, Your Honor, on count 3, the state is going to request that you sentence Robert Olsen to 20 years to serve in confinement. Count 4, which is the violation of oath. Based on his violation of oath that basically led to the death of Anthony Hill, specifically a violation of oath by a public officer in that he swore to support and defend the Constitution, and as you've read from the indictment before, and then did use deadly force upon the unarmed person of Anthony Hill by shooting him with a firearm in violation of the DeKalb County Police Department's use of force policy as contained in the department's employee manual. That is a violation of oath that, again, the range is 1 to 5 in that one, with 1 being the least egregious. Maybe you violated your oath by not filling out proper paperwork, or you maybe did something that was minor in nature that certainly didn't lead to the death of someone. 5 being the most egregious. And this is one, Your Honor, that specifically in the count it says, and then did use deadly force upon the unarmed person of Anthony Hill by shooting him with a firearm. That means that this jury found him guilty of shooting an unarmed, and we know, nude individual, and that was a violation of his oath. And that they had the opportunity, under the justification charge the court gave, to find the defendant not guilty of all of the counts 1 through 4. However, they chose to find him guilty of counts 3 and 4, which, reading that by the plain meaning of the charge and the plain meaning of the indictment and the plain meaning of their verdict, is that they believe he was not justified. It's as simple as that. And if you shoot someone in broad daylight who is nude and unarmed without any kind of defense, without any mitigation, because the jury didn't find that, then that is the worst kind you can possibly think of for a violation of oath, which puts it at the 5. And so we would request on count 4 that the defendant be sentenced to 5 years to run consecutive to count 1, or count 3 rather. That leaves us with counts 5 and 6, and I know that count 6 will merge, or count 5 rather, I apologize. But I want to just talk about them for the purposes of our argument here. You've heard me in my questions to the witnesses point out how important it is to tell the truth. And how important it is that as citizens, we have faith in our police officers that they're not going to lie about what they do. if there is anyone that you should have the most trust in, that they are going to be 100% true on every occasion, it should be a police officer. Like when I asked Sergeant Bradbury, would one sustaining report for professional image violation be one too many? And you heard him say, yeah, generally yes. And that would be the state's position. I get it. You may get a lot of complaints that are unfounded. But if there's one or more that are founded, that's a problem. And I didn't bring up those things to, try to chip away at the defendant. First of all, the court should know everything about the defendant. And so if there are any things that while he was a police officer are relevant, we're going to put those before you, big or small. But what I want to focus on is the fact that not only was he inappropriate with a citizen, and you'll have the opportunity, if you haven't already, to read the entire package of State's Exhibits 93 through 97. But what I highlight for you in that, and I think what came out during the course of the sentencing hearing is, not only did he use the F word inappropriately with the citizen, never recommended that, but what's worse is it sounded awfully familiar to what we heard in this courtroom about his statement to Officer Anderson. Because what happened in that incident in State's Exhibit 94 was that he was confronted about swearing at this woman, and he told the investigators, I did not use profanity in that incident. The investigators said, okay. And then when they sat down with the defendant and actually played the 911 call where the woman is on the phone with 911 and you can hear the defendant say those words, well, okay, it's there, I hear it, but I don't recall saying it. That is awfully familiar to what we heard in this trial when it came to his statements to Officer Anderson. Officer Anderson, who came in here and he told you what he knew, and then was attacked by the defense that maybe he misheard or he was wrong. Well, the jury clearly had no problem with that. To commit a crime by shooting an unarmed man and then exacerbate it by lying about it, that's the kind of thing that we teach our children not to do. Isn't it always what we hear? You're going to be in more trouble for the lie than you are for what you actually did. We try to instill that in our children, that is important, that you raise people to have integrity. Because integrity is doing the right thing even when no one is looking. And the fact that this defendant chose to lie, to cover up what he did, is appalling. That is the far end of making a false statement, the far end of a violation of oath of office. For that, Your Honor, we're going to request 5 years on probation consecutive to counts 3 and 4 for a maximum sentence of 30 years to serve 25 years with the balance on probation. And with that, I'll stop now. May it please the court.
I don't envy you your task of having to impose sentence in a case like this. I've been practicing law now for almost 40 years, and I can't tell you how many times I have heard judges, at least in the context of criminal cases, say there's nothing more difficult than figuring out what an appropriate sentence is. I was in federal court in Augusta a couple months ago, and Judge Hall, you may know, the chief judge of the Southern District, after listening to a sentencing hearing much like this, a full-day sentencing hearing, he asked me, how is it that I'm supposed to weigh in the good deeds, the charitable work, the good behavior, the devotion to family, the volunteer work? How do I balance that with the egregious conduct? In that case, it was a financial crime. How do I arrive at a sentence that somehow takes account of all the different information I've heard today? What is the algorithm that I use to arrive at the correct number of months or years? And of course, you know, and everybody in this courtroom knows, There is no algorithm. We don't have sentencing guidelines in the state court system. We don't have a computer that assimilates all the information and spits out the right number of years for you to impose as the punishment in this case. But we also know that there are, for lack of a better term, generic considerations that the court must think about in imposing the appropriate sentence in this case. Deterrence, punishment, general deterrence, specific deterrence, punishment, and to some extent retribution. I would suggest that the most important factor that the court can consider in imposing a sentence in a case like this is the need of the community for protection from the individual who's being sentenced. Someone who poses a threat to the community in the future, someone by virtue of his or her recidivist conduct who has repeatedly injured people or victimized people. I would suggest that a predator, someone for whom the community needs protection in the future, that is the kind of person that the court needs to impose the maximum possible sentence. I think it goes without saying in this case, and I don't believe anybody in this courtroom believes, that Chip Olsen poses a threat to the community, that he poses a threat to any individuals, or poses a threat to any witnesses in this case. His behavior for his entire adult life until March of 2015 proves just the opposite. His behavior since then proves just the opposite. Whatever we want to say about what happened that day, and the jury has spoken, Mr. Johnson has spoken eloquently about it as well, one thing I think we can agree on is that Chip Olsen doesn't present a danger to the community and doesn't need to be, for lack of a better word, caged or imprisoned for the safety of the community. The second consideration, which is closely related to the first, is the need to deter Chip Olsen himself from the commission of future crimes, that he needs to be taught a lesson, in other words, not just for the safety of the community, but to deter him from committing future crimes. And once again, I think if the court considers what we, as lawyers, often refer to as specific deterrence, there's very little need for that in this case as well. This is not a case in which you need to tell Chip Olsen what you did was wrong, what you did was illegal, you've been found guilty, and to impress upon you the importance of that, and to make sure you don't do it again, I'm going to punish you and put you in jail for a number of years so that you don't do it again. So specific deterrence, I would suggest, is not a factor that would lead the court to impose a lengthy prison sentence. And next is the... Next, the third factor the courts consider generally and that philosophy of sentencing relies on is what's known as general deterrence. And though I don't necessarily think that the public outcry in this case and the protesters and the speeches in the courthouse and at the state legislature are something I want to devote a lot of time to, there have been a lot of comments about the need to teach policemen a lesson. The need to teach, I read one person who said we need to teach white policemen a lesson. And this is, the concept of general deterrence, that we will make a lesson out of Chip Olsen. What we do to him will have an effect in places like Ferguson, Charleston, Chicago, New York City. And we addressed this in our sentencing memorandum, and I'm not going to repeat everything in our sentencing memorandum, but it was interesting that the family and other witnesses all seemed to recognize Chip Olsen didn't wake up that morning and decide, I'm going to go kill somebody. Chip Olsen is not the kind of person who engaged in that kind of behavior. We can call it terrible judgment that he exercised that day with unbelievably catastrophic consequences. But one thing we could never say is it was not motivated by anger. It was not motivated by any evil animus. It was not malicious. And general deterrence is a concept that requires a perpetrator to think about the consequences of his or her action. I'm not talking about specific. I'm talking about the police officer that supposedly needs to learn a lesson in some other case, and that you're going to teach that lesson through your sentence today against Chip Olsen. And the problem with that in this case, the problem with letting general deterrence be a significant factor is if there's a police officer in Chicago or Boston or Seattle who suddenly finds himself in what he or she perceives to be a dangerous situation, or Fort Worth for that matter, perceives himself to be in a dangerous situation, that police officer may make a terrible judgment, like Fort Worth. But one thing I think we can say is that police officer won't be thinking about what you do here today, because it's the very nature of the conduct that's being punished here is that it's not methodical, it's not premeditated, it is not malicious. And that kind of behavior, the behavior of policemen who overreact or who think they're in danger when in fact they're not, can't be controlled by what you do here today. So I would suggest that even general deterrence is a factor that does not lead to the conclusion that a lengthy prison sentence is necessary in this case. And then the fourth factor, which is the only factor I believe that Mr. Johnson is stressing, is the need for punishment, just retribution, vengeance. And that is a difficult factor to quantify. Once again, referring to what I read in the newspaper, and I said that I wouldn't emphasize it, but I'll at least mention that I read that one person said, well, it's an eye for an eye. That's what this is all about. It's an eye for an eye. He took a life, he has to spend the rest of his life in prison. And I would suggest that if we're going to rely on biblical wisdom, there are a lot of other portions of the Bible that talk about mercy, that talk about forgiveness, that talk about compassion. And that an eye for an eye or a tooth for tooth, or an eye for an eye anyways, just leads everybody to be blind. And that is not something that should govern this court's decision here. I saw Ms. Jumo testify, Mr. Hill testify, and Tamara testify. I'm sorry, I don't remember her last name, Tamara. And I can't imagine, unfortunately, what it's like to lose a child. I've lost a child. And I know that it's a lifelong struggle to overcome that loss. And I think they know, because it's been 4.5 years, it's not going to go away. And while they are seeking justice, which is what we're all here today to do, their grief is not going to come to an end no matter what you do. Whether you give Mr. Chip Olsen a life sentence, 30 years, without whatever the parole board does with a 30-year sentence, or whether you give him a sentence that we recommended, I can only tell them your grief is not going to be mitigated in any way at all. The loss of your son, that loss is forever. And whatever happens to Chip Olsen will be forgotten, but the loss of your son won't be. So I agree with them that what we're here today to do is to seek justice. And I have no great help for you, Judge. I wish I could tell you I've got a solution to that for you, and here it is. As I said, I've been doing this for 40 years, and I'm amazed at the different ways in which, especially in homicide cases, including things like vehicular homicide, sometimes the family comes in and says, we know the person didn't mean it. We know the defendant didn't intend to kill my child or my mother or my father. And they seek mercy, and sometimes the family comes in and says, I want the death penalty. And the court has an obligation to consider the victim impact statements. But in the end, you have to decide what the appropriate sentence is and not the family, regrettably. It's an odd thing in this case, my last reference to the protesters, if I may. It's odd in this case that the organization that usually is talking about criminal justice reform and the need to have fair punishment and to get rid of these mandatory minimums and outrageous sentences for people, that is the organization here that is screaming for blood and vengeance. And I'm sorry that that's happened. I think it's inappropriate. So let me talk a little bit about some of the comments Mr. Johnson made about the actual crimes here. An aggravated assault that leads to a death, obviously, is catastrophic. And nobody here knows why the jury did what it did. But for some reason, they found that he was not guilty of murder, either version of murder, and presumably they thought there was some mitigating factor, presumably self-defense. We're speculating, obviously. That they believed there was some level of self-defense that all 12 of them decided warranted a not guilty on the 2 murder counts. And yet, in a spirit of compromise, presumably, or to condemn the conduct in general, they voted to unanimously find him guilty of aggravated assault. I would suggest to Mr. Johnson that there's a lot of reasons, there's a range of punishments of 1 to 20 for aggravated assault. And it's not just, was there a death? I can imagine aggravated assaults where the perpetrator is a recidivist and has regularly assaulted people and threatened people and victimized people. And with or without a death, I think that person's conduct requires a lot more condemnation than someone for whom it was, I'm not going to go through the 6 or 7 seconds business again, but a brief moment in time with catastrophic consequences, but a brief moment in time, when he was 52, 53 years old. That kind of aggravated assault is different than a gang member who has routinely victimized people and threatened people and isn't allowed to possess a gun or whatever. So I don't know that I agree with Mr. Johnson that this is the max when it comes to aggravated assault. It was something that this jury found mitigated the conduct. And I would suggest, therefore, that 20 years, he's not a recidivist, there's no prior conduct, that 20 years is not appropriate in this case for the aggravated assault. But I hope Mr. Johnson's not going to get up and suggest that I'm minimizing the fact that there was a death. I'm not. But it was an assault without premeditation, without malice, and by a person who's never done anything like that before. The conduct with prior arrests notwithstanding. The oath of office, there's 2 oath of office violations. One, they're recommending probation, so I won't spend a lot of time on that. But the oath of office, which is linked to the aggravated assault, is essentially the same crime. So even though they don't merge for legal reasons, because the language in the oath of office offense is quite a bit broader than aggravated assault, and I do not believe they merge. It strikes me as odd that you would, whatever you decide on aggravated assault, that you need to add 5 years for oath of office to that, because it is the exact same conduct, but for the fact that he's a policeman who did it. And the whole oath of office offense is somewhat of an odd offense. He's not being punished for being a policeman. He's being punished because 5 years earlier he took an oath. We all have to obey the law. I have to obey the law. You have to obey the law. Mr. Johnson, Ms. Cross, everybody here has to obey the law. And Ms. Thompson, I'm sorry. We all have to obey the law. So to say, because you didn't obey the law, we're going to tack on 5 consecutive years doesn't seem particularly rational here. And that Mr. Olsen doesn't need to be punished because he was a policeman. He was in this situation because he was a policeman. We mention in our brief something that I wouldn't ordinarily do in a sentencing, which was the plea negotiations, which actually I think Ms. Jumo mentioned before. And it's a matter of public record, so it wasn't, it's not a matter that the rules of evidence would consider to be inappropriate. We were offered to plead guilty to 15 years for voluntary manslaughter. We were told, don't come back with a response other than yes or no. There'll be no negotiation from that point. And we rejected that. And that was made a part of the record during the Lafleur-Frye hearing. I'm not going to question why Ms. Boston or the prosecution team here came up with that number, 15 years, and I'm not going to tell you much about our discussions within our camp. But the bottom line is we were told 15 years on a homicide. And again, I'm uncomfortable because I think plea negotiations shouldn't be a matter of public record, but they were made a matter of public record. We were told 15 years on a homicide, and we said no. And the jury acquitted us of the homicide. And to now say, we think your conduct merited, we used to think your conduct merited 15 years based on a homicide? That's what we thought 4 weeks ago. But today we think you should be sentenced to 25 years even though you weren't convicted of a homicide. We in the defense bar refer to this as a trial tax, that you get punished in this country for going to trial. You get punished in this country for challenging the prosecution's evidence. We all know that plea negotiations are legal and appropriate and indispensable in a country like ours where we have criminalized so much. But we were acquitted of the conduct that they say only merited 15 years as of the middle of September. Chip Olsen did not plead guilty to that offense. And in most cases, the plea negotiations aren't particularly relevant because you didn't plead guilty and you were convicted. So why do you expect the benefit as if you did plead guilty? Well, but we were acquitted. So we're not asking for the same deal after having made the court go through a trial. We were acquitted of the homicide. And I think the prosecution, if in the middle of September this conduct was worthy of 15 years, homicide was worth 15 years, that the sentence ought to be less when he's acquitted of the homicide for whatever reason the jury did that. Mr. Johnson began his closing argument here, and I'm not sure what I'll hear him now, but by saying this is a complicated case and there's lots of issues and you need to consider lots of issues, but other than suggesting 5 years of probation on the misrepresentation count, the false statement count, there didn't seem to be a lot of subtlety or nuance in his argument. And I regret that. I think the state should think about nuance and should think about compassion when they make a recommendation. They have a mission here, and they have a duty here, and they have a duty to the family, but they also have a duty to the community and a duty to the justice system and a duty to you. And I don't think that recommending 25 years in prison honors their profession. You know that I like both Pete and Lance and Buffy, and I don't say that in a personal way, but I think the office should think long and hard about making that kind of recommendation. So, I said to you before, and I'll say again, I don't envy your job. I bet you'd like to be anywhere rather than here right now, having to make this decision. Lucas and Amanda and I have a much easier job than you. We ask you to consider his family, consider his exemplary life before those minutes at the Chambly Apartments that brought us here. Consider his age. Consider what he can do for the community upon his release. He is a human being like the rest of us. He does not need to be caged to protect us or to protect the community. He does not need to spend the majority of the remainder of his life locked up to teach him a lesson. The community and the protesters who have had their voices heard, I'm confident will not reflect back on this day in 5 or 10 years and think, we did a really good deed. Chip Olsen is still in prison, and we really feel good about ourselves. I don't think that's the way they're going to feel 5 or 10 years from now. Again, I urge you not to rely on the principle of an eye for an eye, but to think about mercy and compassion and forgiveness, and to think about Chip Olsen's background and the few minutes that led us to be here today. When I was questioning Officer Walker, you may remember the state's expert, towards the end of my questioning, I asked him about the dangers of being a police officer, which he readily acknowledged. Kathy talked a little bit about that today, and about the wives and families who send the officer off to work every day, and the last thing they say to the officer is always, please come home safe. And I'm asking you, when you sentence Chip Olsen in a few minutes, to please let him come home safe soon. Thank you.
Yes, Judge. Yes, Judge.
Remain seated. Court come to order.
Your Honor, the defense ended their argument with, asking you to allow the defendant to come home at some point. We've got State's Exhibit 1 up on the overhead, which is the photograph of Anthony Hill. The whole reason why we're here is because he was killed on March 9th, 2015. Anthony Hill, who is 26 years old, who fought for his country and went to Afghanistan and came home in one piece safely, only to be gunned down by the ones who were supposed to protect him. You heard his mother testify earlier when she gave her victim impact statement and said she truly believes that Tony was running to get help. And instead of providing that help, this defendant pulled out a gun and shot a nude, unarmed man in broad daylight. And then had the audacity to lie about it. The defense wants some nuance, subtlety. Well, this community has been ripped apart by what this defendant did. You saw the photographs, Your Honor, during the trial of the Chambly Heights apartments and the pictures of kids' bicycles and toys on the porches, and we heard testimony about families looking out and how one of the EMTs said, we've got to cover up Anthony Hill. We don't need to see, have these kids see what's going on out here. This is terrible. This is terrible. And it is terrible. There are folks in this community, folks in that particular apartment complex, Your Honor, who don't call 911 anymore. Because when you call 911, you get killed. That's what the community is saying. That's what we are saying. We trust in our police officers to serve and protect, to swear an oath, to uphold the law, and to do what's right. Not to kill our own. And that's what he did. His shooting was unjustified. And you can say, well, we can speculate about what the jury did or didn't do, but what is a fact is they found him guilty of an unauthorized, unjustified, unreasonable, unnecessary shooting of an unarmed man. There are different tenets of sentencing that we look at when we're considering these things. We've already talked a bit about retribution, punishment for punishment's sake, and that is still important. And the reason why it's important, Your Honor, is because we should have one system, one court of law, one set of laws and rules for everybody. Whether you're an underprivileged person from a community or a police officer, you should be held to the same standards. And in fact, it's interesting to me that during the trial, the defense didn't want Olsen held to the police standard. But now they're saying, well, he was a police officer and it was a tough job, so we should consider all the great things he did as a police officer. Well, which is it? Your Honor, punishment for punishment's sake is sometimes appropriate. But that's not the only reason why the state is asking for this sentence. That's just one of many. Nothing is going to bring Anthony Hill back. We recognize that. I think anyone would say that that is a true statement. But sometimes, in certain situations, a sentence will send a message to the community. And not a message that we're out for blood or anything like that, like the defense is saying, but a message saying if you do wrong, you will be punished. And there's a deterrent factor. As the defense pointed out, absolutely. There's another tenet, deterrence, both specific and general. Specific, obviously, to the defendant. Well, you know, we can stand here and say, well, this defendant isn't a threat. He's never going to do anything again. I don't know. I'm not going to stand here and say that. I'm not going to stand here and say that he will absolutely go out and do something. I can't say that. And I won't. But to stand here and say there is no chance of him doing anything, well, nobody thought he would do what he did on March 9th. Yet he did it. And we don't know really what's in a man's mind or what a person really is about. You heard that from some of the character witnesses, said they know the Olsen they know, neighbor, coworker, but who he really is. And what we've never, ever heard is I'm sorry. We've never heard someone taking responsibility for their actions, whether right or wrong. I get it. You know, the defense has to ensure appeal rights in their case and everything like that, and that's totally understandable, but there is nothing wrong with saying I'm sorry. You know, and as I said, this has torn a community apart. And we need to deter other officers out there. I say we do. You know, if the sentence here is not appropriate, what message does that send? To the police, it sends a message, well, you do this, it's really not that big a deal. To the community, it says, you do this, it's really not that big a deal. Either way, it is sending the wrong message. There has to be some accountability here. And the accountability is reflected not just in the conviction, but in a sentence that means something. You know, it was brought up about the offer that was made prior to trial, and, you know, it's public record, I get that, you know, and also that's necessary. You know, I know the defense knows that it's the state's job. We are required, the Supreme Court of Georgia came out with a case that said we have to put the offer on the record, because if we don't, there was a case where, as the court knows, a defendant said, well, I never knew about that offer. My defense attorney never told me that. If I had known that, I'd have taken it. And that's why we put it on the record. That was the only reason we put it on the record. But to say that his conduct at that time, in the state's estimation, was worth 15 years is not true. In the state's mind, his conduct was worth a life sentence, which is what felony murder would have carried with it. However, it's called a plea negotiation, commonly known sometimes as a plea bargain. And what the state has to do, and this is difficult because there is a family of the victim here, Tony Hill, who is very involved, and they want their justice. There's a community that wants their justice, and then there's a defendant. So the discussion is had, what is the most low number that we're willing as the state to say, we can live with this if that man seated right there says, I am guilty, I was wrong. I shot Anthony Hill and I was wrong. To take responsibility, to stand in front of your honor and say, I was wrong, I am guilty. And not only am I guilty, but you know what? I am not going to even appeal it. Because as the court knows, if he were to accept the offer and plead guilty, that he would give up his right to a trial by jury. He'd give up his right to remain silent and incriminate himself. Give up the right to confront witnesses against him. He'd be giving up the right to assistance of counsel at such trial. He'd be giving up the right to a presumption of innocence. He'd be giving up the right to testify on his own behalf and present evidence. He'd be giving up the right to subpoena witnesses and compel the production of evidence. He'd be giving up the right to have the charges against him proved beyond a reasonable doubt, and he'd be giving up the right to appeal if convicted of these charges at trial. And then the question would be asked, is your decision to waive these rights and enter a guilty plea because you are in fact guilty? Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? That family wouldn't have to sit here and go through what they went through. They would have the comfort of knowing this defendant has stood up and taken responsibility for what he did. That's why that offer was made. And he rejected it, as is his right. If he wants a trial, that's what we do. Right under the Constitution. But to come in here and then say, well, I don't get it. If it was 15 before, it's 15 after, that is ridiculous. Otherwise, why would we even negotiate a plea anytime at all? He rejected it. That's fine. But then you can't go back and say, well, that should be the number or something lower. To go higher would be ridiculous. That's not how the system works, Your Honor. But what is most troubling is that we have not heard a peep about remorse. You know, some of the things that you have before you, Your Honor, are in the defense binder or the defense package that they gave you. I just want to point out just a couple of things because I know the court will be reading it and reviewing it. There is a memo in there from a Mr. Philip Stinson who provides basically statistical information about cases from across the country. First, I would say, I understand why the defense would present the court with that, but I would say read it and then toss it aside. Because what they did in Florida or Texas or any other state is really not necessary for the court to reach a decision in this case. It's what is appropriate for DeKalb County here in the state of Georgia. And what I bring up about it is what we don't know from the information provided by the defense from Mr. Stinson, or Dr. Stinson, is how many of the cases involved lying to cover up the crime. How many of the cases involved a victim who was unarmed and nude? How many of those cases occurred in broad daylight? How many were the result of a call where the police officer responded and had information, and how many were the result of just a happenstance confrontation between the person shot and the officer? How many were judge sentencing and jury sentencing, as we know occurs in other states? How many were an actual negotiated guilty plea versus a jury trial and then a judge or jury sentence? How many involved what we know what the actual sentencing range was? We don't know in how many of those cases what the prosecution actually asked for as a sentence, what the defense asked for, and what the judge ultimately gave. Were there any merger issues, as we have here? How many involved the defendant officer who lied about police-citizen encounters in the past, like we have here? How many involved police officers who had to actually be counseled about their interaction with citizens? How many involved victims who were actually suffering from a mental health episode? The point is, what I stated off to you were not only the things that are missing from that memo, but the things about this case that make it so aggravating. You know, there are obviously aggravating and mitigating factors that you take into account, Judge. We all know what the mitigating factors are. We get it. The defendant has a family. The defendant has a child. You know, they didn't do anything. His wife and his son, they did not do anything. But the fact remains that the defendant did. The fact also remains that no matter what you do, Judge, they are still going to be able to see their husband, their father, their friend. Mr. Hill, Mrs. Jumo, Tamara, anyone else? They're never going to see Anthony Hill again. Only in memories. If they want to go see their son, there's a cemetery in Moncks Corner, South Carolina, where they have to go to see him. This family can see the defendant and visit and talk to and spend time with. That's never going to happen for Anthony Hill. That's never going to happen to Carolyn Jumo and Anthony Hill, Sr. And that is something to take into account. The jury found him guilty of shooting an unarmed person. That's in count 4. Without justification. The jury found him guilty of falsely claiming that Anthony Hill physically assaulted him prior to the shooting by pounding on his chest. That's in count 5. The jury found him guilty of violating his oath by making a false statement to Officer Anderson in an effort to fabricate a justification for the shooting of the unarmed Anthony Hill. Anthony Hill's body wasn't even cold, and he was already lying about it. It's a disgrace to Anthony Hill's name to say he did things that he never did. And he did it for self-preservation. That's an aggravating factor. You shoot someone, you believe that you're reasonable about it, you say that. But don't lie about it. Don't make things up to make yourself look better. And there were lies during the trial. He claims he was sprinting at him, meaning Anthony Hill was sprinting at Officer Olsen. None of the witnesses said he was full-on sprinting. The defendant's the only one who said that. Olsen claimed he lost sight of Anthony Hill and saw him only as he appeared right in front of his patrol car. That's not what the witnesses testified to and not what the evidence showed. The witnesses said he exited the vehicle with his gun drawn and the defendant was 80 to 100 yards or 80 to 100 feet away. That contradicts what Olsen said. Olsen denied having a conversation with Officer Anderson. He specifically said, "No one came up and asked me what happened." That was a lie. It's a lie. And that's not something to be trifled about or say, well, you know, he was shooting and then there's just this false statement. That is an important thing to take into account. What do we say to our citizens of DeKalb County? What do we say to our children? It's not okay to lie, especially if you're an officer. And to argue that it shouldn't be an aggravating factor that he was a police officer under the violation of oath, yes, it should be. And as we have said repeatedly, this is not an indictment of the DeKalb County Police Department. It's an indictment of Robert Olsen. So let's not forget another victim in this case, and that's the DeKalb County Police Department. When people like this defendant act outside what is appropriate, act outside what is reasonable, go outside what the use of force policy says, go outside what the state laws of Georgia say is reasonable and okay to do, that puts a blemish on the police department. And now they're the ones that have to pick themselves up, go out in this community and explain to them, we're not all like that. He's an outlier. He is not what we are about. And it didn't go unnoticed at this table that of the people who came in here to testify on this defendant's behalf, none of which are currently DeKalb County Police Department officers. He was highly trained, this defendant, over 1,900 hours. And he just did what he felt like doing on that day. Didn't follow his training, didn't follow the law, didn't follow what was reasonable, shown zero remorse, and taken zero responsibility. We understand that 25 years is a long time. It is. But the individual in State's Exhibit 1 will be dead forever. And that's a long time. And sentencing is not an easy thing for the court to do. I get that. There's a lot of things that you must balance in reaching what is a fair and appropriate sentence. That's why we didn't ask for the maximum. That's why we asked for what was the maximum on the counts involving aggravated assault and the violation of oath related to the false statement. One of the things that the state wants to ensure by a lengthy sentence like that is not only will it send messages I've already talked about and send a message to this individual, but also ensure that he'll never have a gun again. This defendant should never hold a gun in his hands ever again because he's shown that he can't be trusted. And not only did he have the weapon at the time when he shot and killed Anthony Hill, we found out since then he had 13 weapons in his house. He should not have them, ever, never, because he can't be trusted. We need to restore the faith in this police department within the community, that they can have that faith again. As you know from the quote, "Injustice anywhere is a threat to justice everywhere." There needs to be one system for all. Whether you're white, black, police officer, citizen, whatever you are. The outcome should be the same. And if on the streets of this county you raise a gun to someone unjustified, unreasonable, and kill them, you must be held accountable. And 5 years, which is what the defense asked for in their memo, is not appropriate. 25 years with 5 to follow on probation is appropriate. And we just ask, Your Honor, that you take into account what kind of message this will send. Because right now, whether you like it or not, you're the conscience of this community. And we hope that the sentence that is given to this defendant reflects a conscience that believes this is wrong, this must be dealt with appropriately, and that we will not stand for this, that we need to deter other officers from doing this, other people from doing this, and that this type of thing should never, ever happen again, and no one should have to go through what the Hills had to go through, and Jumos, in dealing with the loss of their son. Thank you.
I think that we all agree there is nothing that I can say or do that will change March 9th, 2015. That is a day that Mr. Hill and Mr. Olsen will forever be tied to, whether they wanted to or not. My role as a judge is to be fair and impartial, to listen to the evidence, to make sure that the law is applied to the evidence, and to make sure that I listen and take everything into account and see both sides. And what I will say to you, Mr. Hill, Ms. Jumo, and Ms. Tamara Jumo, I see you. I watched you throughout this trial, and the fortitude that you showed and the strength that you have shown, and Ms. Jumo, even the compassion that you have shown for the Olsen family is something that is to be desired by everyone. No one can understand how you specifically feel as a parent and as a sister. Mr. Olsen, I watched you through the whole trial. And what I can say is many might have thought that you were stoic and void of emotion. I think I will take something that your sister said, that you're like an egg with a hard shell and a soft side. Because from the time that opening statement started, I saw the tears that you had. I saw how you replayed March 9, 2015 in your head. I saw the quick eye darts that you gave to the screen when images came up. What I will say is, as a family member of someone that is in law enforcement, I understand the role and the duties that are placed upon people that are in law enforcement, the judgment calls that they have to make, and the incidents that they have to encounter. And there is nothing that a civilian can ever do to understand that. But also as a granddaughter of war veterans and a family member of war veterans, I understand what it's like when people sacrifice and love their country and they go to war and they see things that we can never imagine. And they come back sometimes different than they left. And I understand that firsthand. What I will say is that in everything that I did in listening to all of this trial and the evidence that has come on, and in reading all 73 pages and all 25 character witness letters, what I will say is that people might not recognize it, but Anthony Hill and Robert Olsen had a lot of similarities. They both loved their community. They had different paths. They both were loved by their families. They both were musicians. Almost all the time when people come before me, they're here for a lapse of judgment. You are here before me because you made a judgment call in your capacity as an officer. Prior to the trial, the state made an offer of 20 to do 15. I now know that that was for voluntary manslaughter. But before then, when it was placed on the record on September 20th, I knew based off of my knowledge of the law that it was something less than a murder charge. And you declined that offer and exercised your constitutional right to a jury trial, which is afforded to you. And a jury of your peers, people of this community, found you guilty of something less than murder. And that's what I have before me. And what I will say is that based on the charges that you were convicted of, I am going to sentence you to 20 years to serve the first 12 in custody. You will get credit for the 2 days that you served. You are not allowed to ever work in law enforcement. You are not allowed to possess any firearms. And you are not allowed to profit from any event that happened or anything, whether it is television, radio, book publishing, that could transpire from the events of March 9th. And that is your sentence in the order of this court.
Judge, can you specify which counts and how it is?
I will.
Everybody remain seated. Everybody remain seated.
regarding my lack of eye contact, Mr. Olsen, as you know, throughout this trial, I have utilized technology, and I have to advise you of your appellate rights. That is just as critical as anything else, and what evidence comes in, and I am not going to ad-lib it, so I'm going to read you your rights based off of my computer screen. But my lack of eye contact has nothing more than making sure that I get it right. You have the right to seek post-judgment relief from your conviction of the crimes by either making a motion for new trial in this court and or filing an appeal to a higher appellate court. If you want to file a motion for new trial or appeal, then you will need to file a said motion or notice of appeal with the clerk of the Superior Court of DeKalb County within 30 days of today. You may want to fully discuss this option with your attorneys. If a motion for new trial is made and the court denies it, you will have 30 days from the filing of the order or denial in which to file with the clerk of the court your notice of appeal. You have the right to have an attorney represent you on your motion for new trial and at the first level of direct appellate review. And if you cannot afford to hire an attorney, the court will provide an attorney and a transcript to you or your counsel at no cost. Do you understand? All right. That's the order of the court. The attorneys can function.
Hey everybody, so the DA is here, the family is here. What will happen is the family will come and sit, the DA will come up, make some remarks along with the team, and she will invite the family to make some remarks as well, and then we'll open the floor for questions and answers.
All right. Ready?
Good evening. I'm Sherry Boston, the DeKalb County District Attorney, and I want to thank you for joining us. As many of you know, today in the matter of State versus Robert Olsen, defendant Robert Olsen was sentenced to 20 years to serve 12 years in custody with the balance on probation by DeKalb County Superior Court Judge LaTisha Dear Jackson. The state recommended the maximum sentence of 30 years to serve 25 in custody with the balance on probation, which we believe was appropriately aligned with the penalty range associated with the offenses for which this defendant was convicted. While we were hoping for a sentence closer to our recommendation, we are grateful that Mr. Olsen will spend time behind bars and be held accountable for all of his actions. We believe a measure of justice for Anthony Hill has been served and his family's voice has been heard. You'll recall that a little more than 2 weeks ago, on October 14, 2019, a DeKalb County jury convicted defendant Olsen of aggravated assault, making a false statement, and 2 counts of violation of oath of office by a public officer in connection with the shooting death of 26-year-old Anthony Hill. Let me pause for a moment to say thank you to the men and women of the jury. I'm appreciative of their time and thoughtful deliberation of the evidence in this case. While they did not convict on the charges of felony murder, their verdict on the underlying felonies set the stage for this defendant to be held accountable for his actions that resulted in the deadly consequences. Much has been said about March 9th, 2015, so I won't spend a lot of time on the recitation of the facts. What we know about that day is that Anthony Hill, Tony Hill, was unarmed and unclothed, was a man in the midst of a mental health crisis and in need of assistance. Instead, Tony, an Air Force veteran, a son, a brother, a friend, a young man full of promise and hope, was tragically shot and killed, his young life abruptly cut short at the hands of Officer Robert Olsen. We believe that the deadly force Mr. Olsen used to subdue Tony was excessive, unreasonable, unnecessary, and against law enforcement protocol and training. Thankfully, with the sentence imposed by Judge Dear Jackson today, Defendant Olsen will pay the price for his reckless actions and the lies he told in an attempt to cover them up. Let me take a moment to say that this case is not an indictment against all police officers. We believe our law enforcement partners are hardworking, dedicated professionals who put their lives on the line every day and make sacrifices many of us never have to consider. We also understand that this job requires quick judgment calls and split-second decisions. However, we believe those decisions and resulting actions should be appropriate and sound. And if they are not, officers who run afoul of these expectations should be held accountable. Officers should not operate outside of established boundaries and protocols. A badge, a uniform, a gun are not a license to shoot and kill with impunity. We believe Robert Olsen had non-lethal options that he could have employed. But he made a different decision on that day, and that cost Tony Hill his life. Today, we say Tony Hill's name with honor and respect because his life mattered. Now, to a few remarks centered in gratitude. I want to publicly thank the team that you see standing to my left. A team of amazing prosecutors who stand with me today. Pete Johnson, our Chief Assistant District Attorney, Major Case Director Lance Cross, Deputy Chief Assistant District Attorney Buffy Thomas, Assistant District Attorney Lenny Crick, Victim Advocate Tina Williamson, and Deputy Chief Investigator Steve Baresi. Those members of our team have worked tirelessly with unparalleled work ethic, dedication, and passion in seeking justice for Tony Hill. They each poured their everything into this case without complaint, which included long days, nights, weekends, holidays, personal and family sacrifices made with one goal in mind: justice for Anthony Hill. Which brings me to Mr. Hill's incredible family. I am so grateful for their patience in the midst of legal and technical delays, which would stretch this journey in search of justice longer than any of us wished. They too have held their peace and maintained their composure throughout it all. I am grateful for their support, their encouragement, and trust in our team and in our commitment to the pursuit of justice for their beloved Tony. Finally, we appreciate the investigative work of the GBI in the preliminary stages of this case. And as always, we appreciate and value our partnership with the DeKalb County Police Department and our other partnering law enforcement agencies. We could not do the work that we do without their support and their cooperation. While we know that the public lens is focused on several narratives, white versus black, police versus civilian, armed versus unarmed, our hope is that there are larger takeaways. The need for comprehensive and ongoing training related to evaluating and handling calls involving mental health issues. Employing non-lethal approaches to de-escalating situations when warranted. And strengthening our law enforcement and community relations. We promise to continue to work with local citizens, community leaders, our partnering law enforcement agencies to address these critical issues. By working together, we can improve the quality of life in DeKalb County and make our community a safer place for everyone. At this time, I'd like to bring up Ms. Jumo, Tony's mother, for a few remarks. And then after she has spoken, we'll open up the floor for questions.
First of all, I would like to thank everyone, especially the team that we had that was fighting for justice for my son, our son, brother, nephew, grandson, Anthony Hill. I also would like to thank the groups that rallied, stood out in the rain for the many years since 2015. I would like to thank them too. I also would like to thank Eric Echoes, the first person on the scene after my son was killed, who did the leg work, knocked door on door, talked to people, and brought awareness of what was actually going on and what had happened from the witnesses. I would like to thank the media, the ones that were there for me, who spoke the truth, who printed the truth, and was there to tell the story, and just not any story, but the truth, the correct story. I'd like to thank my family. It's been hard, it's been rough, and they have put up with everything. We put our lives on hold for 4.5 years. We do not live here, so we're always traveling. We live all over. No one lives in DeKalb County. I'm very appreciative to them, and I love them dearly. I think that's about all. No, there's one more thing I wanted to say. Fight for justice for Anthony Hill. Even though I didn't get what I wanted the maximum. Some time is better than no time. But if I'm truly happy about it, I'm not. But I have to accept what was given. But if I could, I would want the maximum. Thank you.
At this time, we'll open up the floor for questions.
I have a question. So he is sentenced to 20 years. He's serving 12 years. Is there a possibility that he will get out for good behavior and he won't actually even serve the full 12 years?
When he's eligible for parole will be up to the Board of Pardons and Parole. So they will make that determination.
This question is directed to the family. With this case mirroring the Geiger trial, she was found guilty as well as Mr. Olsen. Did the outcome of that sentencing have any effect on what you were expecting today?
No, because one thing about me, I don't compare or judge anything and what I feel. And I say that because I held Robert Olsen for what he did. I didn't let that set the tone for other police officers because I love my police officers. So I really didn't pay attention to that, and that you can't compare them. They're two different things.
Elena from WAD, but what kind of precedent do you think this case sets for other young black men in this country?
I really couldn't answer that. You probably have to ask a black young man. I can answer as a mother that mothers probably would tell their sons to be careful, be sensible, run away from trouble. And like I said, it's not to bash police officers because I still believe when you're in trouble, you need to, if a police officer, go to them. You can't be accountable for each person. You just have to understand this doesn't set the tone of how I view other people. But maybe Mr. Hill would like to answer that question.
Can you please repeat your question?
Yes, sure. I was wondering what kind of reflection this is on, what kind of precedent this sets for young black men in this country.
Well, until you have other black men stand up and stand on that jury and actually take accountability for actually standing on that jury and taking the responsibility of rendering a guilty verdict, this is what we're going to get. You're fighting an uphill battle, and you're going to have more young black men get killed out there. I mean, don't get me wrong. I'm not trying to sit here and go at the officers or anything like that. But the reality is, it has happened in the past. It will happen again in the future. And until you get people who are willing to stand up and do what is right, and not, run away from their responsibility, their civic responsibility, this is what you're gonna get. I mean, it's a step in the right direction, but it's not where we need to be.
Mr. Hill, how do you feel about that one black male juror on this case who said he compromised felony murder to get some time or to get a conviction, even though he wanted felony murder?
You asking how I feel?
Yeah, that one juror, is that the type of speaking up that you're talking about? I mean, do you think he made a difference in your case? How pivotal was his role?
Well, if in fact it was exactly the way he said, and like I said, none of us were in there. If it was exactly the way he said, then you have to honor him for what he did, because he stuck up for what he stuck by his guns and stuck up for what he believed in. Now, you had a bunch of other cowards that were sitting in that room that didn't do the same. So he's one person. Now I don't know if what he did was what actually got us to where we are right now. I don't know. I mean, none of us were there. But let's say, just for the sake of argument, that he did actually do that. And that is what got us here. You have to commend him for that, because he stuck by his guns and did what he was there to do. He honored his oath, and he did what he was there to do.
Mr. Hill,
Yes.
you had said you wanted Robert Olsen to look at you. What were you hoping to hear from him? What did you want him to say?
I didn't necessarily want to hear him say anything, man. I mean, we're all human beings. And you see someone that has done wrong, right? And I know I've done wrong in the past. And I may not have said the words, but I can look at you, and you know when a person is really sorry, is when you really feel it. He didn't have to say a word to me. You could just make eye contact, and I would know. I would know. I'm human. I'm human, and at no point did I see it, none whatsoever. I mean, I understand the judicial system. Excuse me. Sorry about that, everybody. The judicial system. I know that he cannot speak. He cannot come and say anything to us while the trial is going on. But we walk past each other going to the restroom. I'm standing out there. You walk past me. You can make. I mean, you look at a person. I mean, and it's just that I'm sorry look. I mean, maybe you understand, maybe you don't. I don't know. Some of you may understand that, but it's just a look. You know, nothing ever came. That's all I'm saying. That's all I'm saying.
Does that mean you don't believe that he has remorse at all? What do you think?
My personal opinion, he may have remorse. I mean, come on, he's human. He may have remorse, but I think that he knew what he did, and I think that he made a decision that he knew was wrong, but he chose to go forward with it. You know.
What about the false statement that was made? Does that make it any worse?
Yes, ma'am, it does. In my opinion, yes, it does. It makes it worse. Because think about it for a second. You come into a parking lot, okay? You stop. You see the person that you're there for, kneeling down. You could have stopped where you were. You knew backup was on the way. You knew what you were there for. G22, whatever it was. Whatever it was, G22, whatever, let you know that your person was in a demented state. He's new. You see him, you have him in sight. You know backup is on the way, minutes away. You're standing in front of the building that you say you want a number of, but you chose to drive around and come around the other way so that you can get the same number that you're standing right next to. That didn't make any sense. So that was a lie.
Do you blame the police department for their lack of...
The police department?
Well, for their lack of action against the complaints that were filed against him previously, all those times, and you never really disciplined him harsh enough for him to be out there when it happened to your son?
The police department?
Well, just the administrative, well, just because of the complaints that he had received in the past, the extensive complaints.
Administratively, I think that there were some failures. However, I think those were individual failures. I don't think that was a departmental failure. I don't think that was just a blanket statement for an entire department. I think that you had a few individuals that may have made a mistake. And who they are, none of us will ever know.
Carolyn? Yes. I think a lot of people were expecting to hear from him today, and he didn't. Would you have liked to have heard what he had to say?
Yes, I would have. That would have been something I wish I could have sit down and talked to him and asked him, you know, what actually happened. Tell me the truth. Why did you do that? I would want to hear what he had to say. I don't know why he chose not to talk or why he wasn't allowed. I don't know the procedure, but I was hoping he was going to get on the stand to defend what he did. He didn't.
And to say you're sorry, I guess, or express some or more.
I mean, he could say he's sorry. 4.5 years ago, he could have said he was sorry. He probably would have meant more then. But a sorry, I would take any sorry. Not saying that I will forget, but a sorry means you at least thought about what you did and you feel maybe you didn't do everything right, so I'm sorry. That's what I take a sorry as. But it's been 4.5 years, and he doesn't look me in the eye, you know.
Do you want to hear from him now?
Right now, at this moment, it really wouldn't matter. Because sorry comes to me when you're sorry, not because you got the consequences and then say you're sorry. You can say you're sorry, but it doesn't have the same weight for me. I still would accept it, but it doesn't have the same weight as when it happened. It's like you got your hand in a cookie jar. If you don't get caught, okay, but once you get caught, oh, I'm sorry. When you could say sorry when you knew you wasn't supposed to do that. So.
Maybe this might be a question for the family, could be a question for someone on the legal team. Does it seem as if Robert Olsen gambled and won here because he turned down that plea offer?
I don't think we can speculate about gambling. Clearly, we pushed forward and felt strongly that a murder charge was the appropriate charge in this case, which is why the offer, although it was for 15, was, as Mr. Johnson stated, for him to plead guilty to manslaughter, to voluntary manslaughter, and to accept responsibility that the actions he took were murder. And so they challenged that, as they had the right to do. And we always knew that, as you saw, this jury deliberated for 6 days. We see this all over the country, not just here in Georgia, that getting a murder conviction against an officer for shooting a private citizen is extremely difficult. It's not an easy path, and I am grateful for my team, for all the work that they put in. And again, just by getting the aggravated assault conviction allowed us to be even having this conversation today. I think what you see too often across the nation right now is full acquittals on the serious charges, the felony murders, the manslaughters, the aggravated assaults, which only leave minor charges like a violation of oath of office. But this jury did speak loudly and clearly, despite the fact that they wrestled with the murder charge, but they did hold Robert Olsen accountable for Tony Hill's death by saying guilty to aggravated assault, guilty to violation of oath, guilty to making false statements, covering up his crimes. And so with that, we were able to seek a measure of justice for him and for this family.
The judge in her sentence, she invoked the Son of Sam ruling about making profit off of his death.
Yes.
I don't normally hear judges add that as part of the sentence. Is this something? Was there something that you guys knew about, like a deal or something?
No, I am not aware of any offers of book deals or movies or any interviews that Mr. Olsen can profit from. Why the judge did that, I won't speculate. I can just say that I think she was just making it clear that if there were that opportunity, given the high-profile nature of this case, she wanted the record to reflect very specifically that there should be no profit from this family's loss.
Do you know what the specific breakdown of each count as it relates to the entire 20-year sentence is?
Yes. I'm going to bring up Deputy Chief Assistant Buffy Thomas because she actually saw the sentence sheet, unlike the rest of us.
Hi, good afternoon. So as it relates to the breakdown of the sentence, as to count 3, which is the aggravated assault count, the judge imposed a sentence of 15 years to serve 12 years in custody. So he will serve 12 years in custody. The remaining 3 years will be on probation. As to count 4, which was the violation of oath of office by a public officer, she sentenced him to 5 years in custody to run concurrent with the custodial portion of count 3. Count 5, which was the false statement charge, merged with count 6, which was the violation of oath of office by a public officer, and she sentenced him to 5 years probation as to that count to run consecutive to the sentences in counts 3 and 4.
All right, if there are one last question, we'll wrap it up.
Do we have any idea where he'll go? What prison he'll be sent to?
We do not. That will be a decision made by the Department of Corrections after they diagnose and make a decision on the best place for him to go.
One last one. ADA Johnson talked often about the community. You brought it up often, meaning to the judge. And so the judge was looking out at the community while doing this. In bringing that up, could you explain as to what you were trying to impart to the judge?
I mean, just what I said, which was that, you know, this is the type of case that the community looks at, and we, as the prosecutor's office, have to ensure that justice is done and justice is met, no matter who you are, whether you're a police officer or a regular citizen. And that's why I wanted to bring up the community so that doesn't get lost in this. You know, sometimes our victims and members of the community get lost in it, and all we talk about are the defendants. Defendants are important. That's appropriate sentencing with defendants is absolutely 100% important, and we work towards that every day in this office, towards doing things that are appropriate and not just, you know, rubber stamping. But in these types of cases, like it's been heard already, many times we don't hear much about the victim and the victim's family. We hear about the police officers, or we don't hear about the community that's been torn apart, where they are now afraid sometimes to call 911 because of what could happen, and we want to fix that. And so one of the ways was to bring it to the judge's attention and let her be aware of that when she decided on whatever the appropriate sentence was.
D.A. Johnson, you made a point to mention that there was no DeKalb County cops that came in to offer a statement on behalf of Olsen. What do you think about the witnesses that they brought up to speak on his behalf?
I mean, look, everybody has family and friends, and, you know, the defendant, Robert Olsen's no different. He has family and friends that care about him, and they're the folks that are going to come in and speak on his behalf. I would expect everybody in this room could find, hopefully, a few people who would come in and speak on their behalf. And so, you know, they did what they had to do, and I respect that. My job was just to kind of point out some of the issues with the case that we felt were important that they may not be aware of.
How do you feel about the sentencing?
We're disappointed, but we believe that the guilty verdict and the fact that we got as far as we did is great. You know, that is something that I think, you know, we look at cases across the country and we don't know sometimes going into these cases what's going to happen on the outcome, and the fact that a jury found him guilty, held him accountable, and that he will serve time in prison, and that there is some measure of solace for the family on that, we believe is a good thing.
Does this send a message to police departments, to police officers? You know, you keep hearing about the split-second decisions. What will this do?
Well, what we never want to do is have police officers looking over their shoulder when they're out on the streets, because they do have a tough job, but they have to act reasonably. And I think you have a majority of officers out there, the men and women who work for DeKalb County and all the police departments here in Georgia do their job. And there's the few outliers that don't, and those are the ones that need to be held accountable. And what they need to know is if they don't, then they will be held accountable, and we'll prosecute as necessary based on what they do. We want people to think twice, too. I think that D.A. Boston brought it up, that, you know, the police department and the county have worked towards, since this happened, better training for the officers when dealing with situations like this, that they can de-escalate rather than escalate a situation. And so I think training and education are a big thing that they can do and that any department can do. And I think that the DeKalb County Police Department has done a great job of improving that since this happened back in 2015.
I just want to thank you for recognizing the supporters that were in the room, and there were 35 of us in the overflow room.
And as we wrap up, I am going to invite up Mr. Aaron Eccles just to give brief closing remarks on behalf of the family.
She said Aaron Eccles.
Oh, I'm sorry.
That's okay.
Eric.
It's Eric Eccles, private investigator. First of all, I want to say, and I want to thank Ms. Boston for the comment she made about teamwork. As a private investigator getting involved in a case like this, and turning my facts and evidence that I found over to the DA to secure an indictment. And then them taking that to the next step, which it brought Ms. Boston and her team in to secure the prosecution. It's a testament of someone who's in the private sector as an investigator can work in conjunction with the public sector, with the DA's office, for a common goal, which is justice. And that's the message that needs to be said here today. It's justice for Anthony Hill. And sometimes people out there in the community needs to know it's okay to talk. Oftentimes people don't want to talk, they don't want to give up information. It makes it difficult for a team like Ms. Boston's to prosecute different cases, whereas someone on the public sector, on the private sector, such as myself, can go in and talk to them. But it shows there's a good working relationship. And at the end of the day, we got justice for Anthony Hill. And I think that's a testament to everybody.
Mr. Eccles, do you think that the whatever level of investigation was done before you stepped into the scene, was there little information brought forth because people wouldn't talk to police investigators, or because investigators weren't out there asking you questions?
Well, I think it's a combination, more so that people didn't want to talk to police officers. When you have a history of events like this, where you look at the past and African Americans have been gunned down and shot by police officers, and then you look at the community in which Anthony Hill lived, and let's be honest, it's a Hispanic populated community. You know, there are a lot of people out there who probably weren't illegal. There were probably people, you know, I run across people who have warrants on them, and a lot of times those individuals just don't want to talk to the police officers. So it's not against the police officer or asking the right questions or going to the people. It's just a lot of times the people are afraid to talk to them. Whereas talking to myself or a private investigator, I'm not going to run you to see if you got warrants. I just want the truth, and then I want the facts to support it. And then that's what happened in this case.
Would we have been here today if you hadn't hit the ground running out there?
You know, I've asked myself that question, and let me say this. It was a joint effort of teamwork. I will say I think that the video with Anthony, with Robert Olsen pounding his chest that I found and gave to the DA's office was paramount to convicting him as lying under oath. But again, it was a team effort from myself to the old regime and to Sherry Boston and her great team of people.
Who were you working with? You were a private investigator.
Yes.
Were you doing it upon your own?
Well, at the time, I
or
was hired by the Chestnut firm. I was working on behalf of on the civil case.
Okay.
And oftentimes, when I get involved in wrongful death cases or security negligence, premise liability cases, I find evidence that may be helpful to the police department, and I always give that information to them.
All right, thank you so much for your time and your attention.
Thank you.